Good morning and welcome to this webinar, which is a collaboration between the South African National Editors Forum, the South African Press Council, and the Bhekisisa Centre for Health Journalism. I am Mia Malan, Bhekisisa's editor. So today we're going to look at how to best report on medical malpractice, particularly alleged medical malpractice, and what the ethical and the legal issues are that we need to consider. So you may recall towards the end of last year, there was a case of two doctors who treated a child who had died, and that received very high profile media coverage. And in this case, the two doctors who treated the child were arrested and charged with culpable homicide before an investigation was conducted by the Health Professions Council of South Africa. And the medical profession got extremely concerned that it would lead to health workers refusing to treat patients out of fear of being criminally prosecuted. So today we're going to look at how the media should cover such cases, and of course not just at this one case, but at cases of medical malpractice in general. We've got an incredible panel to help us work through this. We have the media lawyer Okyerebea Ampofo-Anti. We also have News 24's Ombudsman, George Claassen, and the President of the Health Professions Council of South Africa, Dr. Kgosi Letlape, and the Durban-based orthopaedic surgeon, Rinesh Chetty. At the end of these panels who are going to make opening statements, we have Dania Ballett, who is the head of the School of Clinical Medicine at WITS, and she's going to respond to what the panelists said in their opening statements. I'm going to start off by asking each panelist a question, to which they have about 7 minutes to respond. And after that, we're going to go straight into your questions. If you have a question or a comment, please do enter it in the chat box on your Zoom screen. You don't have to wait until the end of the opening statement to enter your question. You can do it as it pops up in your head, and I'll keep an eye on it. And our webinar will end somewhere between 12 and 12:30, all depending on how many questions we'll get. So we're going to start off now straight into the opening questions, and we're going to start off with Rinesh Chetty. He is an orthopedic surgeon and a spinal surgeon in private practice in Durban, and last year he played a leading role in initiating a petition in support of the two doctors that I mentioned who appeared in court after their patient, the little boy, had died. And Dr. Chetty also lodged a complaint with the Press Council about the media coverage of this case. Dr. Chetty, you've been unhappy with some of the media's reporting on alleged medical negligence. Can you tell us about your issues with the media's reporting in general? You can use this case of the complaint that you lodged to explain your issues, but please don't only focus on that case. Talk about the issues, the broader issues that you're unhappy with in general. Over to you.
Mia, can I share my screen?
Yes, you can. You can hit the green share button there at the bottom.
I've just made you host. Yes, I've just made you host, so please go ahead.
We can see your screen, Dr. Chetty. All good.
Okay. Thank you very much for having me. As per your opening question, Mia, just a quick one with regards to private versus public healthcare systems and doctors. Public doctors are employees. Whether you're a prof or whether you're an intern, you have minimal or little liability because you're covered by the state. So often when you get medical negligence reported within the public healthcare system, it doesn't mention the doctor's name. It cites the Department of Health Minister. And all employees under the state are protected under the Labour Act. This is opposite to what happens with private doctors. They run the individual business. They pay their own liability insurance. Their service is solely reputation-based. They form a symbiotic relationship with the private healthcare facilities. And when medical negligence is reported on their behalf, their name, their business, and place of work is often mentioned. It has a direct impact on their reputation and business. I always see when media reports medical negligence as a boxing match. On the one corner, the challenger, who's the victim, is the patient or the patient's family, is fighting for answers and justice. In the other corner is the doctor defending his reputation. He's the title holder. He's the doctor. He's the professional, and we'll talk about second victim syndrome hopefully later. The reporter, for me, is supposed to be acting as the referee. He provides the ring, and he reports to the public and public interest. Often needs to be fair, free, neutral, and the referee needs to recognize the above. The ring only allows the fight to happen. And as you see in this picture, the public are spectators waiting and watching. I've taken off. So before the fight, there's the setup. The challenger and the victim always meets the referee, explains to the referee how they are going to fight. The challenger might have a coach or a lawyer with an unlimited of time to prepare, train, and view the ring. The title holder, the doctor, always has a coach and a lawyer. He often has no little warning beforehand of the fight. He does not know the size or the limits of the ring beforehand. The referee makes courtesy contact with the title holder, who speaks through his coach or his lawyer, and it's often the standard response, which I'm sure the advocate is going to chat about a bit later, but it's confidential. The media versus the ring theory. This is a theory I brought up this morning. Is the media acting in the public's interest? Is the referee acting in the public's interest? Is the referee qualified to be a referee in this type of match? Can the referee recognize and interpret the signs of an unfair fight? Can and will the referee stop the fight if they find a problem? Can the referee spot signs of cheating or problems? Will the referee report these problems or these signs of cheating in further articles? How does a referee declare a winner if there is ever a winner? If they cannot do the above, I feel that you're being unfair to report the story. And if not, you are purely acting as the ring, a channel or device to report a street fight rather than providing fair views. It's not a sanctioned fight, and I don't feel it's in the public's interest. What does a ring allow and serve? The ring allows a public free viewing arena. It allows a fight to occur at any time, which I always ask, what is the timing of this article and why is this article timed in this fashion? Any object that acts purely as a channel is purely an object. There's no referee within the ring. It's a no-holds-barred match, and the challenger has nothing to lose. When the bell's rung, the challenger throws throws the first and all the punches. Their aim is to get the answers, but note that the doctor's reputation is now at stake. The doctor's hands are tied behind his back, whilst his coach shouts out the corner. The standard legal response that advocate Ampofo-Anti is going to discuss. The doctor's reputation takes a beating from day one, which is why I always talk about the timing of the article. Whilst the true fight for answers will continue now with a minimum of 9 to 18 months as per the HPCSA or via the court. I think Dr. Letlape will chat about this later. Whilst everybody waits, are there updates on this fight? Are there updates on the HPCSA rulings? Are there updates on the court evidence, new evidence, post-mortem findings, false accusations, mistakes in reporting? Are the above updates or evidence printed or equally shared as the original articles of negligence? All this occurs whilst the doctor's reputation is taking a further beating. How much does a doctor rely on his reputation in practice? To me, it's everything and it's the only thing. Like everything else, medical care is becoming consumer-driven. This is an article printed in 2018 that talks about the physician's reputation and revenue growth. People Google doctors, people Google everything, as I'm quite sure quite a few people might have Googled me after watching me on this show. Here's an example of a colleague of mine that I Googled. As you see, his practice is mentioned, his entire CV is mentioned, and at the bottom, as you Google him, there's already an opinion piece of a negative nature. So I always ask myself the question, and so should everybody else. The timing of the article, why was the bell rung now? Is an active investigation underway already? Is there any discussion on the consent of a procedure? They often use terms like routine surgery. What is the goal of using these terms? The reputation and loss of income while the doctor waits is a common syndrome called second victim syndrome. Is it a fair fight? And is it really in the public's interest to ring the bell now, or should we wait for all the evidence to be put forward? Thank you.
Thank you very much, Dr. Chetty, for that comprehensive overview of the issues that we do need to look at as journalists. And now that we've heard from someone in the health profession, who has given us his view on what issues to consider. We're going to move on to Professor George Claassen, who is a media ombudsman and who has to decide from within the media sector whether the media is reporting on these issues fairly. George Claassen is the public editor and the ombudsman for News 24 and Media 24, and he's also a distinguished journalism professor at Stellenbosch University, and he teaches science journalism to postgraduate journalists, journalism students, of course. Professor Claassen, what are the ethical issues that journalists need to consider when reporting on crime in general and then on medical negligence specifically? Could you explain these issues by using examples in the South African media? And you could also perhaps refer to the story that Dr. Chetty complained about, as it was a News 24 story, and explain what your decision around that was. Over to you.
Can you hear me now?
Yes, we can. Just before you start, Professor Claassen, we need to stop the screen sharing, Jutsi, to get the presentation. That's it. Thank you. We're ready for you.
Thank you, Mia. Also, thank you to Dr. Chetty. I really appreciate the way he set this out. I've never regarded ourselves as referees, but let me go into the ethical issues, because I also teach media ethics. The preamble to the South African Press Code says that the media exists to serve society. Their freedom provides for independent scrutiny of the forces that shape society, and that means the medical forces also. We are all victims of illnesses and surgery and doctors helping us to live longer, etc. So we report on independent scrutiny of the forces that shape society. And it is essential to realize the promise of democracy. It enables citizens to make informed judgments on the issues of the day, a role whose centrality is recognized in the South African Constitution. The Press Code is very clear on this in the preamble. Then the Press Code's preamble goes on, saying the media's work is guided at all times by the public interest. Dr. Chetty referred to that, although I differ from his interpretation of what the public interest is. Understood to describe information of legitimate interest or importance to citizens. Legitimate interest or importance to citizens. And as journalists, we commit ourselves to the highest standards to maintain credibility and to keep the trust of the public. It's important to keep the trust of the public. If you lose that trust, which we quite often do, it becomes a problem. And this means always striving for truth, avoiding unnecessary harm, reflecting a multiplicity of voices in our coverage of events, and showing a special concern for children and other vulnerable groups, and exhibiting sensitivity to the cultural customs of our readers and the subjects of our reportage, and acting independently. Those are basic principles set out in the preamble to the South African Press Code. I want to go on. In our gathering and reporting of news, the media shall take care to report news truthfully. Is what we are reporting the truth? Number one. Secondly, is it accurate? Or is it only giving one side? And that comes to the third point, is it fair? Are we fair to the doctors? For example, in this case of Professor Beale and his ex-lated colleague, were we fair in the way we conducted it? I don't want to go into that specific case now, but that is a very important subclause of the Press Code. The media shall take care to report news truthfully, accurately, and fairly. Then the second one is the media shall present news in context. Very important, because quite often context is lost in the way. and in a balanced manner without any intentional or negligent departure from the facts, whether by distortion, exaggeration, or misrepresentation, material omissions or summarization. And then thirdly, the media shall present only what may reasonably be true as fact. Opinions, allegations, rumors, or suppositions shall be presented clearly as such. We must clearly state to our readers, or to our listeners, or to our viewers, this is merely the opinion of someone. It is not based on fact. And the press code is very clear, and we must, in the media, must make a clear distinction between reporting facts, for example, the arrest of 2 medical doctors on medical negligence or whatever charge is brought against them, or reporting on a medical malpractice complaint and hearing at the Health Professions Council. That is our duty, to report on the basic facts. There is a case against them, they've been arrested, so we're just reporting the facts. But then when opinion pieces start appearing and comments, we must make that distinction with regard to the latter. The press code is very clear on protected comment. And section 7 of the press code is very clear on this. What is protected comment? And I want to emphasize this. There are 2 points. The media shall be entitled to comment upon or criticize any actions or events of public interest. It is of the public interest when a doctor is arrested for medical malpractice or negligence. And the second point, the media shall comment or criticism is protected even if it's extreme. Please listen carefully to this. Comment or criticism is protected even if it is extreme, unjust, unbalanced, exaggerated, and prejudiced, as long as it is without malice. That is an important thing. Is it without malice? Is on a matter of public interest, has taken fair account of all material facts that are either true or reasonably true, and is presented in a manner that it appears clearly to be comment. That brings me to the question on whether the media are failing in its duty to report health news correctly, and whether the legal profession and courts specifically interpret science correctly. I just briefly want to touch on this. Mia, please stop me if I've gone beyond my time. I'm very nearly finished. In both professions, the legal profession and the media, I dare to say the media and the legal profession quite often fail to understand science and misreport and misinterpret it. In the legal profession, it is called prosecutor's fallacy when prosecutors present cases to the jury based on totally erroneous interpretation of statistics and not understanding probability theory. I'm criticizing my own profession now and the legal profession. And this is so brilliantly pointed out by the mathematicians of Stellenbosch University, Dr. Arnold Miller, in various peer-reviewed articles in legal journals. The infamous Sally Clark case in the United Kingdom on sudden cot death syndrome, where pediatrician Roy Meadow, who stated incorrectly that chance was 1 in 73 million that this could occur twice in one family. It destroyed Sally Clark's life, and Clark was only exonerated when the Royal Statistical Society intervened by showing how the courts misunderstood statistical probability and got it all wrong. We in the media have a serious neglect of proper science reporting. Also in the field of health, and I'm excluding Bhekisisa because they are doing their duty. They're the only ones in South Africa, besides News 24's Health 24, who are doing this. Journalists should be properly trained to report on science and health issues, but they should also have a legal understanding of how the law works. And factual reporting should never be confused with opinion pieces. Let me give you one example from this morning's New York Times. I have a serious problem with the way Pfizer and AstraZeneca and all these vaccine announcements have been made, because none of them have been peer-reviewed. Vaccines Before peer review, remember the Virodine case on HIV, 1997, University of Pretoria. Before peer review, media conferences and news releases should really not take place. I know we're in dire straits with COVID, but AstraZeneca, this morning's New York Times, there's a report about flaws in its announcement about the effectivity of its vaccine. Suddenly, all people are saying the media got it wrong, the medical fraternity got it wrong. So where does this leave us in the media? It's a very intricate problem. And for me as a media ombudsman, as a public editor, to deal with criticism from all sides, it becomes very difficult to deal with this type of thing. Thank you.
Thank you very much for that, Professor Claassen. That's very helpful. And before we move on to our next speaker from the Health Professions Council of South Africa, I would like to remind everyone that if you have a comment or if you have a question, please enter it into the chat box so that I can have a look at it and ask it to and pose it to the panelists. And we can have a discussion around this issue. We are now going to move on to Dr. Letlape from the Health Professions Council of South Africa. He is an ophthalmologist and he is also the soon-to-be outgoing president of the Health Professions Council of South Africa. He founded the African Medical Association in 2006 and is the former chairperson of the South African Medical Association of South Africa. Dr. Letlape, many journalists and medical professionals are in the dark as to how your council investigates a complaint of medical negligence and how long it takes to do so. And as a journalist, I know it can take very long, and I know it can also be challenging to get information from the council. And that relates a little bit to Dr. Chetty's presentation, where he mentioned that what is the timing of a report sometimes, and what information do you mention? Sometimes that is determined a little bit by what you have access to as a journalist. Can you take us through the process and also in your answer explain what is a reasonable period for such an investigation and what kind of sentences can be given to someone who's been found guilty in the health profession? Over to you.
Firstly, I guess I have a duty to clarify that my term as president of council has ended. We are awaiting the announcement of the new president. So I cannot speak on behalf of the HPCSA. But since I have intimate knowledge, having been with the council for 10 years, I can explain its processes from my understanding and my engagements in the last 10 years. And I think the first thing is to consider the fact that the HPCSA, it's a statutory-based tribunal that attends to medical complaints. We don't attend to medical negligence. We attend to medical complaints of any nature, whether it's alleged negligence, whether it's complaints about fees, whether it's complaints about behavior of practitioners. We have practitioners who on the clinical side may be impeccable, but on the social side are found to be rude, etc., etc. So people need to understand that in terms of the Act, we have to take any complaint from patients that have been served by members of the profession, and that complaint can be laid by the patient or by anybody else, even members of the public, on behalf of the patient. But it is essential that patient consent be informed, because what we deal with is healthcare information that is private and confidential. Now, once you have a complaint, it is prescribed in the Act that once we have a complaint, we need to investigate, and we then need to change it into a charge or a complaint that needs an answer from a practitioner. In terms of the Act, once we've sent the complaint to the practitioner and are looking for an answer, they have 40 days to reply, and that is prescribed in the Act. Now, unfortunately, throughout the years, there's been contagion of legality where people are not acting professionally, lawyers have come in, and practitioners procrastinate in terms of answering. They sometimes ask for further information. So it has become a legal process which has become contaminated by the post-94 South Africa that we live in. So there could be delaying tactics because we are a court and it's a legal process. And once we have the answer from the practitioner, the complaint is then put in front of a preliminary committee. So people need to remember this. The registrar and the secretariat are responsible for the investigation. So they are the prosecuting authority. The boards are the courts. So the board will either have a prelim committee of inquiry, or if a matter goes to conduct inquiry, the board will appoint a conduct inquiry. That is the tribunal. So even though we are within the same structure, there are two separate functions. It's the function of the registrar and the secretariat and the legal department to prosecute. It's the function of the board structure to judge, to listen. So they are the courts, they are the tribunal. So it is important that people understand that they are separate processes, and that because it's self-regulation, those are structures of the board. So the prelim committees will be chaired by a member of the board, and it'll have people that are appointed to it, and that's where the complaint and the response serve, and it's adjudicated upon. Now, when the prelim committee adjudicates on a matter, it now has powers to conclude on the matter. They can either accept the explanation, or they could judge and provide a censure, either a warning or a fine in accordance with the policies that guide them. Or if the matter is serious, the prelim committee then has a duty to refer the matter to conduct inquiry. Now, the difference is that at a prelim level, there's no legal representation. You can have legal assistance, but it's the practitioner providing the answers. Even if there's a consultation, there's no legal representation. Your legal person cannot taking rights because it's still at a purely professional level. But once the matter is referred to conduct inquiry, that now becomes a proper court proceeding where you can have legal representation. There would be witnesses that can be called. There'll be expert testimony that can be given by either side, the defendant or the prosecution, and the matter sits there. Now, at that level of conduct inquiry, they can have the same sanctions as can be done at a prelim level, but they can also have a sanction of suspending a practitioner or removing you from the register. Now, at any of the levels of inquiry, whether it's a prelim level or conduct inquiry, the committees have the powers for restitution. For example, if the complaint is that there was excessive charging, the practitioner can be ordered to refund the patient. If the complaint is that there's expenses that have been incurred by the patient because of the practitioner action, the committee can order restitution. But we don't deal with civil claims. That's a matter for litigation that will be taken to the courts. Now, what needs to be remembered is that because we are courts, we are special courts in terms of legislation, the decisions of those structures can be appealed to the High Court. So any aggrieved party that's aggrieved by any decision of the structures, whether it is prelim, whether it is conduct inquiry, they can appeal that decision to the courts. We also, under special circumstances, have appeals processes within the processes of counsel. So you can appeal to counsel. Remember, we've spoken about the fact that the courts are the boards, but you are being charged by counsel, which is responsible for the secretariat. And a matter can be appealed to the structures of counsel, or it can be appealed to the High Court. Now, I think it would be important to speak about matters and principles that refer to the Bill and Munchi matter. When you have a procedural death, there are specific provisions that need to be followed. Any procedural death, which is a death related to someone being taken to theater within 24 or 48 hours, by law, it's a procedural death and an inquest needs to be held. Because we need to ensure that we protect the public and ensure that when you have things like that that are unnatural deaths, they are properly investigated to ensure that we understand why they occurred and we take mitigating steps to mitigate against that unfavorable outcome. And remember that it's not an issue of based on what the outcomes are. It's by law. There's an inquest act. So it's not the discretion of the hospital or the discretion of the physician. And that's a process that needs to be followed. And that's to protect all of us, so that we don't have rogue practitioners or practitioners that might be impaired. And there's a mechanism to ensure that if you have a serious unfavorable outcome as death from a routine, from a procedure, it needs to be investigated. Now, the fact that a medical inquest is compulsory does not preclude anybody from laying a complaint about any of the practitioners registered with us. So there are many instances where patients, families, and those that represent people that are deceased would come and lay a complaint, notwithstanding that the Inquest Act has to be automatically followed. So our process is that we do not wait for inquests. We will follow our processes. Now, here's an important point. There's also a step where the prosecutor can approach the board and say, this is a matter of serious concern. The practitioner poses a danger to the public, and we would like to have the practitioner suspended pending the outcome. So they can then apply to have a suspension hearing. And that suspension hearing also follows due process, where the practitioner would be represented and the prosecutor would be giving reasons why they feel the practitioner should be suspended pending the finalization of the matter. And the practitioner in his defense will provide a defense as to why they feel that is not appropriate. So we've had decisions where counsel has said this practitioner must be suspended, that have been challenged by the practitioner and that have been upheld by the courts. So there's proper due process for everyone on a transparent basis. So what we would appeal for is that if there's a complaint, it should be reported as a medical complaint, whatever the nature of the complaint is. And only once it is investigated will a charge be laid. If we take a lesson from the current challenges at the Zondo Commission, the Commission has laid a complaint with the police. And the police are the ones that can charge the past president. And it is the same policies, and would like the due process to be followed, and would like even the authorities not to exceptionalize, either because of wealth of families or political connections, that this process should be available to every citizen without fear or favor, not dependent on their connectedness or their resources.
Thank you, Dr. Letlape. That was a very comprehensive and great explanation on how your processes work, and it's definitely very helpful for us in the media. So we now have learned more about how does the process of investigation works. We've heard from Professor Clarson about what are the ethics that we need to consider, but what does the law say? And we are very fortunate today to have the media lawyer, Okyerebea Ampofo-Anti, with us. She's based in Johannesburg, and she specializes in media and public law, and she provides advice on defamation law and print and electronic and media law and data protection. And I'm proud to say she's also a Bhekisisa board member. So, Okyerebea, we would like to know today, what are the legal issues that journalists need to consider when reporting on medical negligence? For instance, when can we name someone? When do we need a right of reply? When do we not need one? And can we get sued personally? Or is it just a publication that we write for that can get sued? If you could please tell us about these issues and also alert us to other issues that we need to think about when we report on medical negligence. Over to you.
Thanks, Mia. Well, thanks to all the previous speakers. I think you've really laid an excellent foundation, and a lot of the things that have already been mentioned are also important, not just from an ethical point of view, but also a legal point of view. So when we talk about medical negligence, from a legal perspective, negligence has a very specific meaning. When you say that someone has been negligent, you mean that that person has not acted in the manner that a reasonable professional in that position would have acted. So a reasonable doctor would have acted differently from the way in which this doctor who is accused of negligence has acted. So it's actually important to understand that as a starting point. The terms like this doctor was negligent shouldn't be sort of thrown around as if they don't have any content. And I think Dr. Chetty had pointed out as well, I saw on his slides, but I think he didn't quite get to point to that point about loose terminology, terms like botched, terms like killed. When we talk about defamation law, the words that you choose are really, really important, because those words in your article or in your broadcast are going to be individually scrutinized to understand, well, what do they actually mean? What would a member of the public who hears those words that you chose understand you to be alleging about that doctor? So the legal risk that you face, now having talked about the language issue, the legal risk that you face is one of three things. One is a defamation claim, which would happen in court. The second one would be a press council complaint if it's a print media that's a member of the press council. The third one is a BCCSA complaint, or alternatively, if you haven't subscribed to the Broadcast Complaints Commission, potentially a complaint to ICASA's Complaints and Compliance Committee. So those are the three legal risks that you would be facing. And in the interest of time, I want to kind of just sort of bundle them all together, because we're just not going to have time to break all three of them down. But in essence, from a legal perspective, if you publish a statement that a doctor has been negligent or is accused of negligence by a patient or the patient's family, that is understood to be a defamatory statement, because as Dr. Chetty had already mentioned, it has an impact on their reputation. And the reputational harm is potentially very severe, because it could lead to the end of that doctor's career, it could lead to the end of their business as a doctor, etc., as members of the public would choose to avoid them even before they are found guilty in any court kind of process or an HPCSA process, simply based on your reportage. So from a defamation legal point of view, that allegation that a doctor has misconducted themselves from a medical negligence point of view is understood to be defamatory. From the BCCSA and press code point of view, other speakers have already mentioned that you are required to ensure that whatever you publish is truthful, it's accurate, it's fair, that statements are not presented as a fact if they are based on rumors or suppositions, or if it's unclear. So those are the aspects of those professional codes that you need to be concerned about. Also, the press code specifically talks about exercising care when you're making an allegation that will impact on the dignity or reputation of an individual, which obviously an allegation of medical negligence will impact on the reputation and dignity of the doctor concerned. So that's the risk. How do you mitigate against that risk? Oh, and sorry, Mia, just to speak to your question about who's liable for that risk. The liability rests on every single person who is part of the chain of publication. So the patient who approaches you and says, I went to Dr. So-and-so and my procedure was botched, that person is making a defamatory allegation, they are liable. The journalist who writes the article and is responsible and is therefore responsible as part of the chain of publication, they are liable. The publisher of that particular story, or the broadcaster, so if we're talking about a print media organization, that print media organization, if we're talking about a broadcast organization, if it's a television station, a radio station, that organization. And strictly speaking, it can even go as far in the print context as the store that carries copies of that newspaper, but that never really happens. But in theory, it could happen. So everyone who's involved in the chain of publication, you must never as a journalist believe that by virtue of working for the newspaper, you can't be sued in your personal capacity. However, what often happens in practice, certainly that I've seen, is that your publication would take responsibility for it, and they would effectively indemnify you because they would pay out the legal fees and they would pay out whatever damages is awarded against you. I've certainly never encountered a scenario where the broadcaster or the publication will throw the journalist under the bus and say, you go and deal with it yourself. I haven't yet come across that, which is not to say you shouldn't be concerned, because of course your reputation as a journalist is also on the line. So what are your defenses then? How should you be mitigating against this particular type of risk? So there are three potential defenses that you need to keep in mind when you are writing a story of any kind that is defamatory, and certainly a medical negligence one. The first, most obvious one will be truth and public interest. Is what I'm going to publish going to be the truth, and is it in the public interest? Well, medical negligence, I would argue, a story about medical negligence is almost always in the public interest, because if a doctor is misconducting themselves, any member of the public can fall into the hands of that doctor and be harmed. And so it is in the interest of the public for the public to be aware that this has taken place. That's a different question as to whether it is true or not, of course. And it's a different question as to the ethics of your timing and when you choose to publish. And I think here I just want to pause to say that ethics and law are not the same thing. The law may often allow you to go much further than what your ethics might potentially allow you to go. But in law, if it's in the public interest, then you can publish it. You don't have to wait until a particular point. Then secondly, we're looking at, is it true? When we look at truth, we're talking about truth or substantial truth. Substantial truth doesn't mean true in every single detail. For example, if you say, well, the patient arrived at the hospital at 6 and the doctor only came to see them at 6:30, and that 30-minute time difference didn't make a substantial difference to the outcome, then the fact that you made a mistake in your article and says it was at 6 or at 6:30 is not really relevant. However, if that 30-minute time difference is crucial to the outcome for that patient, then it is a substantial inaccuracy and untruth. So the truth is not truth in 100% detail, but it is substantial truth. The difficulty, of course, with truth, both in court and even if you are at the BCCSA or at the Press Council, is that it's a little bit more difficult to establish that something happened as a fact. And I would certainly advise that when we're talking about medical negligence, it's a very specialized area. Medicine is a specialized area. That's why people train for 6 years and then go and do community service and all of these other things to become doctors. So it's a very difficult thing for you as a journalist to stand and say, well, I've heard this and it's medical negligence. I think it would have to be the most glaringly obvious of things in order for you as the journalist to really truthfully be in a position to make that type of expert conclusion. The more complex something is, the more careful you need to be as to a conclusion that this is what actually happened. And that's why I would always advise that when you're dealing with an allegation of medical negligence, you should be careful to see whether you can find an independent doctor who can comment and advise you, even if they don't want to go on the record, because often professionals will be reluctant to go on the record against another professional. So they may wish to have their identity, concealed as a source, which as a journalist, you're also entitled to have confidential sources and to have that protected constitutionally. So I would definitely advise, seek the input of independent medical practitioners to say, what the facts are that this patient alleges. Yes, it sounds like negligence. Don't just go out there on a limb on your own because you think it's obvious that the doctor shouldn't have done this or should have done this. And I think the other important thing for you to consider as a journalist is that the mere fact that someone has died or has been injured or permanently harmed in some way does not equate to negligence. And that's why, terminology like routine operation is questionable from a legal perspective, because someone can go in for a routine operation. And if you've ever been in hospital, the doctors will tell you every operation is potentially life-threatening, because if something goes wrong that is not expected, you could end up being harmed. So to use terminology like it was a routine operation, but yet the child died, doesn't prove anything, that it should have been simple and should have been obvious. And that's why it's really important for, you as a journalist to get that expert input. So that's the issue of truth. Secondly, we talk about, in defamation law, reasonable publication. And there's also provision made for this as well in the press code. And the BCCSA, it doesn't state it in the BCCSA code, but in the rulings of the BCCSA has also taken into account the issue of reasonable publication. So what does this mean? It means even if I can't prove definitively that it is true, what I have written or published is true, can I show that I have been reasonable as a journalist in the manner in which I have taken steps to put together this story? And this is where, Mia, the question you asked about right of reply comes in. And I'll get to right of reply. So how do you show that you were reasonable? There are a number of things that the courts will consider to look at whether you were reasonable. One of them, and this is not, it's not a hierarchy. These are factors that will be put into the basket. One of them is, is it balanced? The tone. Are you what is it that you're actually saying? And that goes back to my point at the beginning about what is the language that you're using. If you're going to use emotive language like this was a botched operation, this doctor is a well-known maverick, numerous allegations of XYZ and so forth, then even if you try to couch it as allegations, the overall impression that might be created by your piece is that the person is actually a problem, should be avoided, is suspicious, or has even done it, whatever the patient says they've done. So you need to be very careful about the tone and the language that you use. The less evidence you have, the more careful you have to be about the tone and what you're actually saying the doctor has done. Secondly, is the issue of how have you taken steps to verify? And this is where my previous advice about try to get another doctor who's an expert to look into the matter and tell you what they think about it. If you've got, for example, I've seen stories in the past about someone who's putting themselves out there to say, I'm a plastic surgeon, but many of the people that have been to them end up having to go back for multiple corrective procedures, for example. Then how many sources do you have? Do you have one disgruntled individual, or do you have 2 or 3 or 4 or 5 people telling you the same story? You've got a pattern that's much stronger than if you've got one person and one incident that's being put under a microscope. For example, this unfortunate incident that took place last year of the young boy that died, that was one incident that is now under the microscope. That's a very different thing from a doctor with a pattern of botched incidents or problematic incidents. So steps taken to verify. How reliable is your source? If you've got a source coming to you, for example, if you've got a nurse coming to you from a hospital and saying, here are, medical records that I can show you confidentially that shows that this was reported to the doctor, but they didn't act. This was reported to the doctor, but they didn't act. And this is someone who's close to it, who is treating the patient, etc. So how reliable is your actual source is very important. If it's just the patient coming to you and saying, I took my child there, or I went there and I was harmed, or I took my child there and my child died, that's not a source. That's someone who's disgruntled and who says this happened. And how do you then verify what they say? And then the next point is this issue of right of reply. Very, very important. Have you given the doctor, the hospital, the nurse, the service provider an opportunity to put their side on record? But one thing that's important to remember when it comes to medical negligence, it's not that easy for a hospital or a doctor or any healthcare provider to fully respond to allegations of negligence in the media. And the reason for that is that ethically, they are not allowed to disclose the details of a medical process to third parties. Even from a legal point of view, in terms of the National Health Act, a doctor or a hospital can't simply pull out, the file on a patient and start showing you as you would expect. And of course, as a journalist, this kind of goes against one's instincts, right? Usually you're expecting the person who you're giving the right of reply, if they're playing open cards, to come out and say, this is the detail of what happened. If I've got documents, I can even show you the documents. A doctor and a hospital can't do that because it's illegal unless you have written consent from the person who's making the allegation that they received the problematic treatment. That doctor cannot provide you with the detail. And I think that's really important as a journalist, because often what happens, and I mean, I've worked with journalists for over a decade, what often happens is that when you give someone a right of reply and they appear to be cagey and they say, oh, it's sub judice and so forth, then there's a cloud of suspicion over that they don't want to respond. But with doctors and hospitals, it's a bit different because they can't really respond. So you need to think about how you position their failure to respond in the article, and it shouldn't be positioned as some kind of stonewalling by them. So that's reasonable publication. I'm sure I've gone over time, but the last point I want to make just for 30 seconds is on fair comment, because that was also mentioned before. Now, fair comment is the defense that allows you to publish an opinion. This is where you get your opinion pieces and so forth, or your sort of JJ Tabani's rant. You know, that's where you have your opinion that is now going to be put out there. What is really important about fair comment, though, is that it must be based on facts that are true or substantially true. And when you're dealing with a defamation case in court, and even when you're dealing with a BCCSA matter, the Press Council doesn't really mention this, but in both court and the BCCSA, it's a clear principle that the facts on which your comment is based must also be referred to or broadly known. So you can't simply say, well, I think that doctor is absolutely shocking. When is the HPCSA going to deal with him? Without saying why. What are the facts on which you base it? And I would really, I guess, caution journalists on the issue of fair comment and medical negligence. I think this links back to my first point about negligence being an issue of expertise and it being potentially problematic for you to express an opinion on facts that you may not actually understand. And also, if you do choose to go and then express that opinion on those facts, to what extent and what detail do you then present those facts in your article? And the reason why the presentation of facts in the story is important is because members of the public must draw their own opinion and conclusion of the facts. They mustn't take your opinion as a fact. They must take the facts as the facts and your opinion as an opinion. And my last point there would be to say, very, very important if you go down the opinion route, that not only must your facts be true, adequately stated, but even your opinion must be couched as an opinion and not as a fact. And it's highly questionable as to whether when you say someone was negligent in the performance of their duties as a doctor, there will always be debate as to whether that's a fact or an opinion. So it's definitely an area for caution there as well.
Thank you very much, Okyerebea, for those practical tips. I feel like we can make a bullet point list and follow them. So thank you very much for being so clear on these points. Before we move on to our last speaker, I'd like to read a comment that has been made by Natalie Zimmerman in response to what Okyerebea said, and that is, remember also that an expert needs to be an expert in the specific field being commented on. Getting a pediatrician to comment on the treatment of an elderly patient may not be credible, for example. And I think that is, Okyerebea will agree, that is an important point to remember. We're going to move on to our last speaker before we get to questions and comments. And that is Professor Dania Ballot, who is from the University of the Witwatersrand, and she heads up the School of Clinical Medicine there. And she's also a renowned pediatrician with a subspecialty in the field of neonatology, which is a field that looks at the care of very young or newborn babies. So Dania has a special experience because she's a doctor herself, but she's also a family member who have experienced the consequences of alleged medical negligence on a personal level when her husband died. So Professor Ballot, you've worked through the long process of laying a complaint of medical negligence with the Health Professions Council of South Africa. And we've now heard from a lawyer, the Health Professions Council, a media ombudsman, and also another doctor. What is your response to what has been said? How would you respond to this, and how would it help your case? Is it usable in your case, and what has your experience has been? Over to you.
Thank you, Mia, and thank you for this opportunity. And I've really been invited here in my role as a patient. And let me tell you that this has been a shocking revelation. I have worked in the medical profession for more than 30 years. I'm very familiar with death and litigation and all the rest of it in the public sector. And the whole time we are scared of being sued. And I'm very interested, Dr. Chetty, that you use the metaphor of a boxing ring with the victim as the challenger. It sure feels like that. Let me tell you that I have learned that being a patient in the private sector means you are completely on your own. And I've been listening to all these discussions, and I've heard lots about the doctor's reputation and the consequence to the doctor and disgruntled patient or family members, I'm hearing nothing about the patient's pain. And believe me, the pain is immense. And unless you've actually lived through it, I think you cannot experience it. And it does trouble me immensely that there's no focus on the patient and the patient's pain. And it does make me wonder what we are teaching our medical students and how we are teaching doctors to treat their patients. Because, I mean, whether you are in a private healthcare and running a business, the patients literally put their lives in your hands. And you, whether you are private or public, are accountable to that patient. And professionalism and compassion are qualities that all doctors should exhibit. And I'm not hearing that in this conversation at all. You know, my husband went in, and I am going to use the word routine planned surgery because it was booked, it was elective. He had the operation, he was readmitted with post-operative complications, and he died. And if you can think of any of those terrible TV things in the hospital where you call to say, come to the hospital, and you go to the hospital and they died, my children are screaming, doctor. The very last time that he communicated with me or my family in any way. I don't know why my husband died. I mean, I understand the cause of his death, but I understand he died from vomiting blood. I don't understand how that happened. What happened? Why? What on earth went wrong? And in trying to find answers, I have written, I have spoken, I have done everything I possibly can think of to pretty much every single body in the whole thing. And I'm a person who comes from the game. I'm in the game. I know people. I have written to Richard Friedland, the head of the private healthcare group, a lawyer response. You write to HPCSA, you don't hear anything. I have a lawyer to speak on his behalf in HPCSA, but I can assure you that his defense has been prepared by expert lawyers, and he uses expert witnesses. The patient is not even asked. I'm not even asked to go and give an opinion or asked what happened. Nothing. So the patient doesn't have a voice. There's no system in the public, in the private sector to represent the patient. The procedure-related death that Dr. Letlape referred to is true. If a person dies as a consequence of surgery, there is supposed to be an autopsy and an inquest, which is actually the missing link, if you want to put it that way, which does make the doctor accountable and have to explain to the patient. But people don't do it. It just doesn't happen. It didn't happen in my husband's case. So we didn't have an autopsy and we didn't have an inquest. And this is now being used in the doctor's defense. There wasn't an autopsy, so we can't say what happened. If I wish to appeal the outcome of the HPCSA as a patient, I have to do it at my own cost in the High Court. Then people say, well, sue the doctor. You don't sue for negligence, you sue for money. And you have to sue for loss of support. So if a child dies, for example, there was no money lost. I happen to be financially independent, so I can't argue. It's not worth the contingency lawyers taking on my case because it's not financially beneficial enough. So I can do nothing. So the image of being in a boxing ring and being beaten into submission by the private healthcare group, by the doctor, by the Medical Protection Society, by whoever else feels like jumping on me is really quite powerful. You know, there's no advocacy group for patients. Nobody. And nobody knows what's going on in private practice. You don't. I don't know if this happened to the next guy, the last guy, 15 other guys. If you start talking, it's amazing how commonly this sort of thing comes up. Literally, the only conversation, the only communication I had from the hospital, the doctor, anybody, was the nurse in ICU phoning me on the day of my husband's death to ask me if they could put him in the fridge. That is all. That is the only communication that I had. And I'm a colleague, apart from anything else. But I mean, is this how we treat patients? For me, it is absolutely horrific. And the question that I want to ask all of you is, what will you do when this is you? Because everyone kind of thinks, oh, the public sector, which is so terrible, we can go into the private sector. Do you know what? There are lots of problems in the private sector that must be fixed. It's not okay. How I have been treated and my family has been treated is just simply wrong. And it's not okay. And, you know, nobody does anything. Nobody supports you. Nobody takes you seriously. And all you get, wherever you try and find an answer or whatever, is a big fat door shut in your face. You know, and I didn't believe it was like this, to be quite honest. I've worked in the healthcare sector for many years. I've got family members who are in private practice. I've always thought that the health sector was good in this country, and I have learned to the contrary. And to sit and say nothing is wrong. So I apologize for articles, but really it's something that has to be brought into the open and fixed. Just can I close that in the public sector, there is a system of accountability. I think the editor spoke about peer review. In the public sector, we are used to working as a team and we are used to having peer review. We have a system of morbidity and mortality meetings where our treatment cases that had a bad outcome can be discussed and reviewed. How can we do better is really the thing. And in the public sector hospitals, there is a very strong quality review process where if a patient does have an issue like me, I can go to somebody in the hospital who will take me seriously and interview me together with whoever and all the rest of it. There's nothing like that in the private sector. So thank you very much.
Thank you very much, Professor Ballard, and also for sharing the details of your case so bravely. Dr. Chetty, I can see that you nodded a lot while Professor Ballard spoke. I would like to pose your question, Dr. Ballard's question to you. If you were the patient and you are a private sector doctor, right, and you are fighting for the rights of private sector doctors not to be portrayed badly in the media, what would you have done if you were Professor Ballard, and how would you have liked the media to cover that case if you were the doctor in question? What would have been fair to you?
Let me first off saying is that my condolences to Prof Ballard. It is an unbelievable experience to go through losing a family member. I think most of us have been through it. And to happen in the way that she's described it is obviously causes some form of serious stress. When I lose a patient, I'm a spine surgeon, I lose patients with broken necks, often in December. I don't take leave in December. Patients and family members often traveling down from Transvaal or from Gauteng break their necks. Their families are here. I've got children often without their parents because they've passed away from major injuries. They undergo something called a grief cycle. And grief is a powerful thing. Every single patient undergoes grief if something's happened to them. Every single doctor undergoes grief. Every single family member undergoes grief. And grief often is exhibited as anger. And anger is often mistaken as untreated grief. And I agree when Prof. Ballard talks about patients not having this avenue to get answers or an avenue to work through the grief. There's 5 grief processes that occur. And anger is
Dr. Chetty, sorry, Dr. Chetty, I'm going to interrupt you in the interest of time so that we skip the grief conversation, but go to how would you want the media to cover this? If you were the doctor in question, what would you have considered fair in coverage here and what would not be fair?
Do you want me to comment specifically on the case?
You know, this could be a scenario. So if you we have details. And you could imagine when you also mention that the access of information, that there's not a lot of access in the private sector, you could imagine what the challenge for the media would be to get access to information if they cover such a case as if the patient can't get access.
You see, the issue behind access is once again communication, opening up the lines of communication. Post-operative loss, or patients that lose family, especially the patient themselves, need to undergo post-trauma counseling. It's something that I pay for in my practice. I ask the patient to undergo post-trauma counseling, not only because she can or he can get the answers. I sit in on those meetings and I discuss it with the patient. You need to have your door open. And the patient themselves also need to understand the door needs to be open, as well as their door needs to. It's a two-way thing. Often hospitals offer post-trauma counseling to aggrieved families that have undergone situations like the one we're discussing now. And like I said, anger is a difficult thing. So if you open up the lines of communication, you can strike this problem you can nip it in the bud. And there might be no need for a journalist to get involved. There might be no need to put in articles in the newspaper, as long as we can work the process together.
Okay.
So the issue.
Thank you, Dr. Chetty. Thank you for that. I'm going to, in the interest of time, move on to Dr. Letlape. Dr. Letlape, when you investigate a case at the Health Professions Council in South Africa, the media often complains that it's very, very hard to get information from the council. And I have personally experienced calling 10, 20 times and not getting sufficient good, credible information to quote. What is it that needs to be improved at the council to make access to that type of information a little bit easier? Because it's not just me who has that experience. If you talk to journalists in the media profession, they all have that experience with the council.
Well, it's like wanting to go to the court to have ongoing comment on a case that has not been concluded. And I think what needs to happen is for us to understand that our processes, we work like a court. And when a matter is ongoing and it's still being argued, it's difficult to try the case in the media and let due process follow. Because you can then create a mistrial. Because if you're talking about issues on a matter that is still being argued, the defense can then argue a mistrial, that they are in your process, but you are also trying them in the media. And I think there has to be a maturity of understanding how these things operate so that matters are not jeopardized. We have cases where things have been commented upon while the case is ongoing and the whole matter has fallen apart on the issue of prejudice and that there's a bias and that we are already expressing an opinion on the matter. I think part of the issue is that people need to understand that conduct inquiries are open to the public. Our processes are open to the public. So if the media is really interested in these things, just like they have access to courts, you go to court, you listen, and you report on what you are listening to. To expect a person that is a participant in the process that is ongoing to be giving comment at the same time is to compromise the case. So I think we just need a better understanding of what the challenges are. A prosecutor must present his case in court, in the committee, not in the public space. And because the committee is open to the public, if the media are interested in reporting, they can come and there's a chair, and just like you apply to participate, etc., those things can be done. So as I've said in the beginning, we act like a court of law and the same rules apply. And I just want to comment on what the prof was talking about. Well, one of the things that concern me and concern those of us that are in health administration, in health politics, is that health services has now become without care. Compassion has been taken out of services. And we need to find a way of bringing it back. Accountability needs to happen. Peer review happens in the public sector, in the academic institutions. When you go to smaller hospitals, they have no capacity to have morbidity and mortality meetings. We need to create a system that cares. We need to create an ability, no fault compensation, so that people can be compensated, not because they have deep pockets, but because we are an accountable system. We've got to be transparent, but we've got to be properly resourced to have that transparency.
Thank you very much, Dr. Letlape. That was very useful. And it's good to know that the media can then attend some of the cases. Okyerebea Ampofo-Anti has indicated that she would like to respond to this as well. Okyerebea?
Thanks, Mia. So I just wanted to clarify, in case my presentation came across as indicating that there are so many barriers that it's virtually impossible for an article to be written. That's really not the case. To start off with, the question of public interest is really key. And that is whether or not it is in the public interest for people to be informed about the fact that there has been potential malpractice. What is really important is for journalists to learn, and I can't stress this enough, not just in the case of medical malpractice, but every other type of case, to learn how to couch a story in a manner that enables you to still tell the story and get the information out there whilst ensuring that you are protecting yourself legally and staying within the bounds of ethics. And I think that often what happens is that journalists feel like they either have to choose between the two sometimes, that either, oh no, this is too dangerous, I don't have the information, I can't publish, all these problems, or alternatively, I'm going to go out there and make it look like I know exactly what happened and who the culprit is and so forth. And those are not your only two options. So it's not to say that if you have grieving family members who approach you and they are in a scenario where the doctor, there's no accountability. You know, the HPCSA is taking forever. There's no basis for a legal claim. The doctor is stonewalling them. Then your situation as a journalist is just to say, well, I can't do anything about it because I don't want to be sued. You can potentially get the story out there. And of course, often grieving families will end up approaching the media because they feel like it's the only way to apply pressure on the situation, to force the accountability of institutions to start acting because now they don't want to be embarrassed. And I think we cannot underestimate the importance of the media in contributing to that, because of the fact that unfortunately we do live in a country where a lot of things are broken, and often, you know, we only see action when the media steps in. So it's not wrong for the media to step in, and it's also not a requirement, by the way, that as a member of the media you remain neutral. The law is very clear on the fact that your article isn't only lawful because you are neutral. So you don't have to say, well, I don't know what happened, and I'm sure the doctor's also right. You don't have to adopt a neutral position. But if you do decide to take a position that I think the doctor is wrong, you have to make sure that you've really ticked all your boxes in order to go down that route.
Thanks very much, Okyerebea. George, I would like to bring you in here, because what do you do as the media if you report on a case like of a doctor where there's alleged negligence, and you can't access information from the Health Professions Council when it takes too long to get it, and the doctor in question doesn't want to comment, and your story then potentially comes across as on the side of the patient, although you have right of replies, I've sent them out and you don't get replies. What are the ethics that you need to consider in such a case to make sure that that story is balanced? You're on mute.
Sorry, can you hear me now? It's a very difficult thing, Mia. We in the media are in fact holding up a mirror to society. And people tend to forget that. They tend to blame the messenger all the time. And they do it in courts of law, and they do it before the press council. I get lots of complaints of people blaming us for holding up this mirror. During the American election, News 24 has been blamed by a host of mostly white Afrikaners and English-speaking people of being against President Trump. And we were reporting what was happening in America. It becomes a very difficult thing. The problem for the media is that when it comes to science, for example, and reporting on medical issues, is that the media have been accused, because of the lack of knowledge, expertise, knowledge of science and health issues from the side of journalists, that we are holding up a dirty mirror. So we are reflecting the real issues through a dirty mirror, an opaque lens, which is in very many examples very true in South Africa and worldwide, where news desks have been closed with regard to science. There are not one designated science editor in the whole of South Africa at any media institution. That is shocking, to say the least. Why is science so neglected? And this has been emphasized during the COVID crisis, because suddenly journalists have been challenged to report correctly and ethically correctly and legally correctly on COVID. And the statistics held from us by various institutions, for example, from the medical side, that we may not have access to the information, so that we have to reflect both sides of the story, and now it becomes reflection through a dirty mirror. It makes my job as a media ethicist, as somebody who has to try and protect News 24 and our journalists, but try to protect the public also, to be fair to the public and to everybody around, because we have to be fair. We should be accurate, we should be truthful, and we have to be fair. And it makes it immensely difficult when information is withheld from us. And I think that's part of the problem Justice Zondo has at the moment also, for people who don't want to attend these hearings.
Thanks very much. That's very helpful. And I would also like to ask, I see one of our participants in the webinar is Mike Bridge, who is the press officer of the organization Medical Protection, and they help doctors with protection. And I would like to know, Mike, if you would like to comment on, when do you advise doctors or the people that you protect to speak to the media? When is it a good thing and when isn't it? Are you there, Mike? Mike Bridge? Okay, I see Mike is muted. So I'm going to move on to someone else who would like to make a comment, and that is Natalie Zimmerman, who wanted to make a comment about patient engagement. Natalie, would you like to go ahead and do that?
Thank you very much. I think for me, there are a couple of issues. The first of all, the family should be and is absolutely allowed to be outraged. And we should expect the family to be able to express their pain. That doesn't mean that what they're saying is true, and that is where the role of both the journalists and the inquest party has to come in. And so we do place quite a high expectation on the journalists. I do also completely agree that our institutions are not all working the way that they should, and that they should be held accountable, and that continued pressure to do so and to get answers should be definitely something that we want to do. But unfortunately, our adversarial system and the fact that it is a clinician's livelihood that is immediately at stake means that it is very hard to answer before a process has taken place. And that has to be done so carefully, and especially with doctors, and I'm from the Society of Anesthesiologists, and our doctors are there to keep patients safe. That's their primary job. Their immediate reaction, if something goes wrong, is to blame themselves and to want to engage with the family. But that is not always the truth. It's just their own emotional reaction to what is a very distressing circumstance to them and to the family. Obviously primarily to the family. But that is also one of the reasons why we're very supportive of mediation, because that is a protected environment. It's unfortunately protected from the media and public interest is a question that needs to be asked, but protected from both the media and the legal processes allows for the answer that Prof. Ballard is asking for, allows for an open engagement, allows for the doctor to express their own pain at what has happened to the patient and to hear, which is absolutely critical, the pain of the patient to what has happened to them or their family member. So you'll see that mediation is happening more and more. It is supported by the indemnifiers. I see there are a couple of them online, such as Ethical and MPS, and also by the professional societies. So we've just enabled a peer review process that works with mediation. It doesn't, and I think that Dr. Letlape is quite right, it doesn't override anybody's rights through a court of law, through the media, and through the HPCSA to follow any process, but it may allow for some of the answering of the questions in a much shorter way and more comprehensive way than you would be able to get through a formalized, procedurally driven inquest or legal process. So we encourage that.
Thank you very much, Natalie. It's very helpful to know that there could be a process of mediation as well for us as journalists. Dr. Chetty has indicated that he would like to ask Professor Claassen a question. We have about 3 minutes left before the end of this webinar, so we're going to end with that question. What is the question that you would like to ask, Dr. Chetty? You on mute.
You know, I just want to clarify. I didn't come about to start this complaint and shout very loud. I tried really, really hard to engage in the reporters, especially when I picked up the problems with regards to News 24, couple other channels. I literally engaged with them. I've got the proof, whatever it is. But I found it very disheartening that even though as a qualified medical professional that is willing to go on record, as well as went on record with News 24, as well as a couple other reporters, that I was either given a whole lot of red tape, or I was told that I can come back at some other time and have a chat. And I think we've discussed this, Professor Claassen and me. I think you've got the transcript of my comments. So I'd just like to find out if doctors do want to come about, and if doctors do want to open up the lines of communication, especially with reporters, are they not obliged to print that publication or listen to the publication, or at least open up the lines of communication themselves?
Thanks, Dr. Chetty. Professor Claassen, your response.
I think Mr. Groenewald from the Press Council said we won't discuss this specific case, but I'm totally prepared to say that as a press, as an ombudsman or a public editor of a media organization, reply to every little complaint I get, every comment. I make it my duty to do that. The reader must know that they are listened to. And I do that, and we did change the sound recording, the interview that Dr. Chetty complained against, and I gave him, I agreed with him that there were certain sections of it that were really not acceptable, and they were removed and edited out of that, of those interviews, that interview. So I look at the press code, and if the press code says something specifically that we did wrong, and I have a very good relationship with my editor-in-chief, Adrian Besson, and the whole editorial team, who accept the fact that we subscribe to the press code. And the press code is vital in the sense that we have to be fair, we have to be accurate, and if we are unfair and we are contravening the law or the press code, we have to correct it and update stories. And I'm absolutely open to that. I am not protecting the media at all. I don't believe it is fair to protect the media. I'm a journalist myself, but I'm also a scientist who has published widely, and I know the contradictions that quite often happen here.
Thank you very much, Professor Claassen. We've come to the end of our webinar. We're at 12:30 now when we need to end.
Mia, before you end.
Dr. Chetty, we're actually, unfortunately, at the end of our webinar. You can discuss afterwards, perhaps with Professor Claassen. I'd like to end with a quote. that says what is most crucial for news organizations and what is most useful to the public is news that is delivered in a manner that is beyond reproach journalistically. And that is a quote from Michael Gettler, who is a former editor of the Washington Post and an executive director of the International Herald Tribune. And that is perhaps something that we should all aspire to as journalists. I'd like to thank all the panelists for their valuable input and really the insights and the helping us to understand ethics, the law better, and also the plight of patients and how we need to approach these issues. There will be a recording of this webinar available on the SANEF website. We might also put it up at Bhekisisa. So if you'd like to re-listen to it or share it with someone, please go to those two websites and see there will be a recording within a day's time or so or two. And that is it from us for today. Thank you very much for joining us and for all your participation. Until the next SANEF webinar, it's goodbye from me, Malan.